So thank you very much, Amy, for giving me the sign to start here, and welcome to the ICCI Christfield Pavilion here at COP29. It's a great pleasure to be here with you today, and warm greetings also to the audience online. My name is Petra Minnerup, and I'm Professor of International Law at Durham University and also the Director of the Center for Sustainable Development Law and Policy. And it's a real pleasure to be here, especially speaking to climate scientists and scientists generally, because I'm not a scientist. I'm a lawyer, and I would like to bring a slightly different perspective today. I hope you can bear with me, because there will be some law involved in this, but it's not as complex and difficult as you may think. So please, let's try to really embrace this interdisciplinary dialogue, because I think only when we make this real effort, and it is an effort for me as well to understand the science behind this. And in fact, I've just been in a conference with school children who ask all of these questions about climate science. And they're very difficult questions. And likewise, when you as a scientist have to deal with the legal questions, it is not easy, but I think we can make this work and then inform policy making, inform lawmaking. And I think this is something that we really need to see coming out of this COP as well. So what I have promised to do in this event, and I will speak for around 30 minutes and really would like to invite your questions as well throughout the presentation, is to talk about the ITLOS, the International Tribunal for the Law of the Sea advisory opinion on climate change. Now, as you know, climate litigation has grown in the years. There are more than 1,000 cases filed in national, regional, and international courts. Now, what we have seen more recently is that climate change has landed in the international courts. We've got proceedings in the Inter-American Court of Human Rights. We had a first decision of the European Court of Human Rights. We've got another decision pending with the International Court of Justice, which is, of course, the highest court of the world, the court that decides contentious and also advisory opinion cases at the highest level. But then this decision is specifically in relation to the United Nations Convention for the Law of the Sea, where we've got a particular advisory opinion request placed before the tribunal to answer these questions. Now, these questions are extremely relevant, and the decision is very, very positive. It's a real positive outcome, and we should focus on how can we take some of these statements of the tribunal further in science and law research. So these are the questions that were asked by COSIS, the Commission of the Small Island States that formed to bring this question before the tribunal. These were the questions before the tribunal. What are the specific obligations of state parties to the United Nations Convention on the Law of the Sea, including under Part 12 of the Convention, to prevent, reduce and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change, including through ocean warming and sea level rise and ocean acidification, which are caused by anthropogenic greenhouse gas emissions into the atmosphere. And the second part was, what are the obligations to protect and preserve the marine environment in relation to climate change impacts, including ocean warming and sea level rise and ocean acidification? Now, you must imagine, we went into this advisory opinion not knowing what greenhouse gases mean for the marine environment. Are there pollution? Are there degradation? What is it? We don't know. I will tell you that the International Law Commission, when it drafted articles on the protection of the atmosphere, said that releasing greenhouse gas emissions into the atmosphere is not pollution. Climate change was seen as degradation. So not pollution. Now this has changed now, and we will come to that. So what are the obligations under UNCLOS? the United Nations Convention for the Law of the Sea, and climate change law generally. Now, the tribunal will reflect on how can I bring these different pieces of international law together in one advisory opinion. And for that, it was very important to observe the rules that are set out in the convention. So, and this means that the convention obligations will be read in context with other pieces of international law. They will contextualize, they will interpret it to harmonize these different rules. So we have specific obligations of states under the law of the sea, but also under the UNFCCC and the Paris Agreement, and of course human rights treaties, but that is a different issue altogether. So here the tribunal said, yes, it is possible to interpret the obligations and the provisions under the convention in the context of the international climate change regime. So to come to that conclusion, the tribunal has to refer to general rules of treaty interpretation. They can't just make it up. And these rules are custom international law, but they're also laid down in the Vienna Convention on the Law of Treaties. And here the tribunal referred to this convention. It also referred to the jurisprudence of the International Court of Justice to buttress its own approach, yes? It will not just say, this is my approach. It will say, this is in line with what we have seen before. Now, the International Court of Justice confirms that treaties do not operate in isolation, but are interpreted and applied within the framework of the entire legal system prevailing at the time of the interpretation. So whatever is the law at that time will play a role. So now, then, with that in mind, the tribunal here had the opportunity to say, we will interpret UNCLOS in line with Article 4, Paragraph 1 of the Paris Agreement. And here the tribunal notes that parties want to reach global peaking of greenhouse gas emissions as soon as possible, recognizing that peaking will take longer for developing country parties, and to undertake rapid reductions thereafter in accordance with best available science, so as to achieve a balance between anthropogenic emissions by sources and removals by sinks. So the tribunal considers that the aim set out in this provision is consistent with the obligation under Article 194 of the United Nations Law of the Sea Convention. So now it then went into the detail of these different obligations, and I will try to guide you through the different findings of the tribunal. Now, the key provision here was Article 194 of the Convention. Now, this provision in paragraph 1 requires states to take all necessary steps and measures to prevent, reduce, and control pollution of the marine environment from any source. So this article lays down an obligation that is common to all states. So what needed to be decided first was, are these greenhouse gas emissions a form of marine pollution in the meaning of Article 1, Paragraph 4, subparagraph 4 of UNCLOS? And here the tribunal found that the introduction of carbon dioxide and heat, so two things, greenhouse gas emissions and the heat that they produce for the oceans into the marine environment, anthropogenic greenhouse gas emissions cause climate change and ocean acidification, which results in the deleterious effects illustrated in the definition of pollution of the marine environment. So they take the definition first in the not bold print, and then they subsume, yes, greenhouse gas emissions are in fact a source of marine pollution. And that is a really critical statement. And that is also critical for how we deal with this in the coming years, building from this decision. Now, this is the formulation of Article 194 in the treaty text. States shall take individually or jointly as appropriate, take all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment. So this is the starting point for the state obligations. So what is then a necessary measure? That is, of course, the next question. What does it mean for state A to do in order to prevent? Does it mean they just have to do something and see what comes out? Or does it mean they have to land at a certain result? Is it an obligation of conduct or one of results? That is one of the key questions here as well. So, necessary measures. The tribunal here developed this as follows. It said that in the tribunal's view, there are various factors states should consider in their objective assessment of necessary measures to prevent. So it's an objective measurement. It's not subjective. The tribunal was very clear this is not down to the discretion of the individual state. It needs to be objective. And this is where the science comes in. The science tells what is objective. It's not up to the individual state. So with regard to climate change and ocean acidification, the best available science is found in the works of the IPCC, which reflect the scientific consensus. Now, again, this is really important. We see many treaties in international environmental law that refer to the best available science. And we don't really know what is the best available science. What is the latest science? Who is the scientific community? So the law opens itself to science without guaranteeing that this is the best available science. There's one exception, and that is the IPCC. The IPCC produces scientific evidence in line with the general mechanisms of international law, because this is an intergovernmental panel on climate change. So this means that the reports are scrutinized by parties and approved. And this ties in very well with these mechanisms of international law. It's not only a few scientists saying that, although we could debate if not a peer-reviewed outcome should also be best available science, but it is approved by states. So therefore, it is much more easier, much more profitable for the ITLOS to take this science into account and to say this is actually the best available science, the IPCC reports. So then the tribunal also has to balance, of course, what states will agree to. So it has here then added that it wishes to add at this juncture that in determining necessary measures, scientific certainty is not required. In the absence of such certainty, states must apply the precautionary approach in regulating marine pollution. And that is also very critical. If we have no scientific certainty, it's not an excuse not to act. We must act even in the light of scientific uncertainty, and that is in applying the precautionary approach. There is a discussion in international law. Is this an approach or is it a principle? So let's settle on approach as long as it is applied. It's really critical to say that this is applicable, and for some it even constitutes customary international law that applies to all. So it is very important to know that this is applicable in this context of marine pollution. This is why it was so important to state first it is marine pollution. All these principles that hinge on the definition of pollution will come in at that point. That is the precautionary approach, there is the polluter pays principle, there are very other principles that come in at this point. So why do COP decisions matter? And this is actually something that Tom Pearson and I discussed a while ago, and we submitted something to the Global Stockpact in that regard. These COP decisions interpret the treaty as we go forward. So whatever comes out of this COP29 will have an interpretative effect. For the Paris Agreement, the CMA decisions, for the UNFCCC, the COP decisions. And now even the tribunal recognized that. It said that the Paris Agreement has a dual temperature goal, well below 2 degrees, ideally 1.5 degrees. And this has been strengthened, for example, through the decision adopted at COP27 in Sharm el-Sheikh, which reiterates that the impact of climate change will be much lower at the temperature increase of 1.5 degrees Celsius compared with 2 degrees Celsius. And this is really important to have these science-informed top decisions that really bring home this point that yes, 1.5, or ideally, I know that some may have been part of this research that suggests even 1.5 is too high. We should aim for an even lower temperature target for maintaining the ice sheet's integrity. So it's so important that this science raises its voice and ensures that these top decisions are informed by the science because of their interpretative effect. It matters a lot what is said in terms of the science and in other terms. So the tribunal also agreed that there is differentiation between these obligations. It clearly stated all states have these obligations under 194 and under other provisions. But there is also the common but differentiated responsibilities principle. So it agreed that there are some countries who may not have as much of a capacity to act and to prevent and to reduce greenhouse gas emissions. Because this is something that is really clear from the advisory opinion. The reduction of greenhouse gas emissions is a state obligation under UNCLOS. Yes, so the scope of measures will vary between different countries. Now, this is now in one slide, all the different obligations that arise under Article 194 in accordance with this advisory opinion. We didn't know this before. This was really the interpretation of the tribunal under the law of the sea. And here you have put this in bold, the most important ones. I know it's too much text, but I cannot take some bits out. It would not be correct. So the really important one is the necessary measures include, in particular, those to reduce greenhouse gas emissions. It is a state obligation. It's not saying how much, and there is the principle of differentiated responsibilities, but it is an obligation to do that. This is really important. We cannot pretend this is not relevant, and I think it's important for this COP as well. Now, this obligation to take all necessary measures is an obligation of due diligence. Again, very important. Due diligence means it's an obligation of conduct, and you have to do your very best. You have to apply really the greatest standard here. And now the tribunal also had to say something about the standard of due diligence because the standard can vary. And the tribunal said these standards are very high if the risks are so great, like they are in climate change cases. So this is why we have a very stringent, a high standard of due diligence. So the concrete obligations, you may ask, what does it mean for my country? So for your countries, it means an obligation to harmonize policies. It doesn't mean you have to achieve that fully, but an obligation to work towards a harmonization of policies. And that includes policies that affect state authorities, but also the private sector. States have an obligation to control what the private sector is doing in terms of greenhouse gas emissions. That is also something to be found in this very rich decision. And then there's also a duty not to transfer or transform and use of technology. So by that, I mean not to transfer or transform, so no damage or hazards from one area to another. So you really, in this transboundary context, have to observe this due diligence obligation to not allow, if there is an oil spillage, for example, or anything else, in this case, greenhouse gas emissions, to cause transboundary harm in the territory of another state. So that is the first paragraph. The second paragraph of Article 194 has something that we call almost like an elaboration of the no harm principle. It requires states to take all measures necessary to ensure that the following two situations do not occur. First, activities under their jurisdiction or control do not cause damage by pollution to other states and their environment. And second, pollution arising from incidents or activities under their jurisdiction or control does not spread beyond the areas where they exercise sovereign rights. Sovereign rights are not just exercised on the land, they're exercised in the territorial sea, in the exclusive economic zone, and on vessels. Yes, so all of these could be sources of pollution, and states have the obligation to control. So very important here again, I highlight the very important one in the middle in bold. It is the obligation to take the measures to ensure that anthropogenic greenhouse gas emissions under their jurisdictional control do not cause damage to other states and their environment, and that pollution from such emissions under their jurisdictional control does not spread. So greenhouse gas emissions, because they form marine pollution, are included in this obligation under 194. And here comes in the science, because the standard is again high, due diligence, stringent standard, but the tribunal at this stage also hinted that the question of when do we have a causal link between damage and emissions is a different question altogether. There could be scientific uncertainty, and how we find this and establish this causal link is a question for the science, and a question probably also for compensation cases. But I think this is really something to take forward in scientific research. Is it possible through attribution studies, for example, to say this is something where we can establish a causal link between emissions and damage? Now, there are many other obligations, and for comprehensive detail, here I've listed all of them. So there are various obligations arising under these different articles. Pollution from land-based sources needs to be controlled, from vessels, and the pollution from the atmosphere. And it's not just about legal frameworks, setting them up, it's also about enforcement. There are clear enforcement obligations. If a state party to the convention, which is bound by those rules and standards, fails to take such measures, so have these instruments in place and oversees the implementation of these instruments, its international responsibility would be engaged for breach of the obligations under Article 213 and 222. So this is again something for many people. International law does not have enough teeth. This is a mouthful of teeth. Yes, this is a very clear obligation to enforce these rules, because if you don't, international responsibility is engaged, and that means you've got measures such as compensation, restitution, and damage claims. So there are secondary rules. You could bring a claim if a state fails to discharge these obligations. Again, very important, there is the duty to cooperate. This is not just something like a nice set of words. It's a clear legal obligation to cooperate. In international environmental law, this duty takes away these national self-interest of states in the interest of environmental protection. And the tribunal here voiced its view to say that the duty to cooperate is reflected in and it permeates the entirety of this Part 12 of the Convention. And it also referred again to the other treaties to which parties to UNCLOS have also signed up, like the Paris Agreement and the UNFCCC. And this is not just an obligation at the time of ratifying the treaty, saying, look what we've done, we've signed up to this treaty, now it's in place. It's a continued obligation. It doesn't stop. Again, something to emphasize at this COP. It's a continuity of the cooperation that really matters. It requires states to make an ongoing effort to formulate and elaborate these rules. The adoption of a particular treaty, such as the UNFCCC or the Paris Agreement, does not discharge a state from its obligation to cooperate, as the obligation requires an ongoing effort on the part of states in the development of new or revised regulatory instruments, and in particular, in light of the evolution of scientific knowledge. So again, this is so important to understand for the scientific community and the legal community to say, we've got a strong case. You're not fulfilling this duty to cooperate because you're not taking the latest scientific evidence into account. There are then very concrete obligations, in fact. So I've talked about this policy and the policy streamlining harmonization efforts. And so this duty to cooperate extends into that area. So states should cooperate really to find the relevant scientific criteria for their domestic regulation. So this duty to cooperate then filters down, of course, to the level of national implementation. So they have to develop an effective common regulatory framework. And this presupposes the existence of adequate information on the state of the marine environment, again, science, and it must be based on the updated scientific criteria and methods. So the new research really matters. And the in-between the IPCC reports matters. I don't think it's reasonable to say, in light of these findings, to wait until we have the newest findings in the IPCC AR7. There are then also these obligations to monitor who is doing what on your territory and your vessels. Yes, this is the obligation to monitor private conduct, but also state conduct, and to implement an environmental impact assessment. So whatever a state undertakes in the context of permission for power plants, there needs to be an environmental impact assessment. That is recognized as customary international law. There are concrete conservation. I'm coming to my final slide, so please start thinking about the questions. There are very concrete obligations also in terms of conservation of living resources, struggling fish stocks, and so on, because the tribunal recognizes that all of these are threatened by the impacts of climate change. And there is again also the obligation to consult with one another in good faith with a view to adopting necessary measures and effective measures. Good faith is a very important word in international law. We have to negotiate in good faith and we have to implement treaties in good faith, because there is no police force that can really regulate what states are doing. So thank you very much for your attention. And I promised Amy I could speak a bit about the case on glaciers, but I will leave it here. If you've got any questions, maybe we can answer those. And thank you. I know it's a late evening already, but I would really welcome some discussions.
This is a different part of the law of the sea, but I was wondering if you've heard of Tuvalu's case to ensure perpetual statehood under the law of the sea. Tuvalu's case to ensure perpetual statehood under the law of the sea.
Yes, I know, but it's very different. Yes. Yes, so in terms of, so that's another issue really. So if we talk about sea level rise, so this was about marine pollution. That's the first important step. But then, of course, a very pressing question for states is, especially small island states, what happens to coastal erosion? What happens if they are at one point submerged by water? What happens to their statehood? And so some of these questions are being addressed in the International Law Commission's work on the international law and sea level rise. There is no real answer to that yet. So we will see what happens with that case. So I would be not really inclined to make any assumption in this case. But it's, of course, the question of, for statehood, we need to have certain criteria. We need to have a population. We need to have an effective government. We need to have a territory. I mean, there have been very innovative suggestions being made, including one of my PhD students. He's looking into or has looked into the metaverse. Can states exist there? But to be honest, there is really no clear answer to that. What happens in this state-state relation, and what happens to human rights? What happens to displaced people? What happens in those situations? So there are many, many, many facets of that as well. Any other questions? To the next one. The next. Yes, so this is a case that has been pending in German courts since 2015. It's a case brought by a Peruvian farmer, and I'm sure you will have heard of it. It's the case of Lear against RWE. RWE is the biggest German energy provider. They produce more greenhouse gas emissions than some smaller countries. Now, you could ask, how is it possible that this farmer in the Andes, who lives in the city of Huaraz, you can see that, that's below here, how can he bring a claim in Germany? Now, we have RWE headquartered in Germany, and there's a specific provision in the German Civil Code that is a nuisance provision. It's meant for situations where one neighbor suffers from the apples that fall into his or her garden from the trees of the neighbor. Yes, it's this situation where you say, can you please cut these branches, or I cut the branches, and then you have to reimburse me. Now here, this is very similar, but it's a very distant case, of course. So the Peruvian farmer claims from RWE pro rata contribution to adaptation measures, because as you can see, the pipes that are there, they will not be sufficient to ease the water pressure if bigger ice slabs from the glacier fall in to break up and fall into the Lake Paltacoja. There could be a flood wave. This flood wave could then submerge the city of Huaraz completely. And the property of the claimant is in the city of Huaraz. So he claims pro rata in proportion to the contribution of RWE for the historic emissions. You have heard, of course, of the carbon majors report. So if we say there's a certain proportion that RWE has contributed over a certain period of time, to calculate the cost that the reimbursement would be to pay for adaptation measures, for safety measures put in place to ensure that people are safe. So he either asks RWE to do it, or he will do it and ask for the reimbursement. So it's a nuisance claim in that sense. And it's led by a law firm in Germany. Roder Verheyen is leading on this case. And in the first instance, the court in Essen held that there is no causal link between the greenhouse gas emissions of RWE and this problem here. And as you know, this is the very classic understanding of how we find a causal link in law. We ask, would this risk be there but for the greenhouse gas emissions of RWE? So the court said, well, this is a multifaceted problem. Many contributors have contributed to this increase of the flood risk, and we can't point out which of these contributions have been or could be allocated to RWE. So no causal link, and therefore they said this is not an admissible claim. But then there was an appeal filed, and now the higher court of appeal in Hamm has in fact even undertaken a site visit to take evidence by eyesight. So they went to Peru to see what's actually happening. And there are different questions now still where proof has to be provided, but the court has held, and only then will they enter into the evidentiary stage, that it is conclusively argued. So what that means is there is a case. So if these questions that are now out for proof can be answered positively through the science, then there could be a case, and that, of course, would set a precedent. I mean, Germany is not a common law, it's a civil law jurisdiction, but still this would set, of course, an example for other courts and for other situations as well. So now the questions that they have to answer is, have these has this increased risk resulted from greenhouse gas emissions, and is it possible to objectively measure the contributions of RWE over a certain period of time? And now in that context, and it's with these, that it's really important to understand the role of attribution science, which is a new kind of scientific area that promises for us lawyers quite a lot in terms of providing us with the necessary evidence to construe these causal links. I can go through more of some of these more theoretical backgrounds. So with a scientific expert, actually, Freddie Otto, Imperial College London. She works on climate attribution, world weather attribution, extreme event attribution. We thought to understand why we are in climate change still in this very unfortunate situation where we find courts that apply this extremely strict causal link. Because in law, we have other areas where it's equally difficult to find causation, and nevertheless, we come to the conclusion that there is a causal link. A key example is asbestos. In asbestos cases, when claimants developed lung cancer, it was often not possible to establish who of the many employers they were with failed to provide them with safety measures. And in the absence of that knowledge, courts found that they still need to do justice. And even if we cannot find but for, this would not have occurred, then all of them are responsible. There is something like joint and several liability. So they set aside these very strict causal tests. So we thought this is one way of doing it. And looking at this, how difficult is it to understand loss and damage, to find any normative correctives? Can we find another way through these new attribution science to alleviate these very harsh outcomes of applying causation in this strict technical sense? So we look into attribution science. I give you a very quick overview. This is science stand, so you all know about it, but the basis of this attribution science are to say that while it is generally impossible to say this event would not have occurred without human influence, it is possible to ask how the risk of this type of extreme events occurring has changed due to external factors. So the dices have been loaded. It's not 1/6 of the probability to find any one number, but our human activity have loaded the dice so that 6 comes far more often. And this is what probabilistic event attribution can do. They can tell us how much more likely have certain events become. So these are some of their evidentiary statements. Over the last 12 months, human-caused climate change added an average of 26 days of extreme heat, and this would not have been possible without a warm planet. Without human-caused climate change, temperatures of 40 degrees Celsius in the UK would have been extremely unlikely. Now here you can see how it is important that the tribunal said we don't need scientific certainty. We can deal in law with extremely unlikely, very likely. We can reflect that. So it's a myth to assume that the law has 100% certainty in cases involving scientific facts. So you can see these statements on the relation between attribution science and how this could be relevant in the law. Now, these causal links often play not so much a role in claims against governments because they are mostly based on human rights provisions, where it is sufficient to have a general statement about causation to understand that extreme events are caused by climate change. But in tort-based litigation and in our starting case, the LIA case, nuisance claims, these strict tests do prevail. So whenever there's compensation or restitution in the horizon, we will see that these very strict tests are applied. So now we thought, how can we access this? How can we change this harsh causal analysis? And we thought there are only two ways. One is to apply normative correctives, as has been done in asbestos cases. where we say afterwards, well, actually, this is too harsh. We have to set aside the harshness of the test, or we assess the logical fundamentals. And our claim is that this is the coherent way of doing it. We need to add logical fundamentals to this. We know it's a long time already. These are 2 more slides. It's not as complex, and I know some of the ECRs are really listening very well. So I will continue with this. They'll give me maybe 3 more minutes. So we established that across this chain of causation, we are looking into the quantity of emissions, the increase in global mean surface temperature, the impacts of a changing climate consisting of a general tendency of increasing frequency and severity of some weather events and climate-related slow onset events. So these are the heat waves in the global north, the precipitation increase in Bangladesh, flood events, yes, a class of events that shares characteristics. And then against that background, we can establish one specific event, that is the specific heat wave in 2023, for example, that is the occurrence of a concrete climate change impact. So between these 4 factors, there is a causal relationship, and the strength varies. And interestingly, what we found here has now been used by the UK Supreme Court in the Finch case, Finch against County Surrey Council. So really interesting case where they have actually used these different strength of causal links. So in the mind of the lawyer for establishing causation, we normally use necessity and sufficiency. These are the 2 logical fundamentals, but they are not sufficient to portray attribution science. So we say, in accordance with Judea Pearl, who revolutionized, I think, causation across sciences and social sciences, we need sustenance to measure the impact of a factor that contributes as a cause to a set of conditions. Greenhouse gas emissions will contribute. They're contributory cause, concurrent causes. And then we can establish how do we link these different factors. Now, between emissions and the temperature increase and this distinctive causal field, we only use necessity and sufficiency. That is acknowledged. We have enough science really to say there is a causal link between these. And then we use something you will be very familiar with, the transitivity theory. If we have a causal connection between A and B and C, we have a causal connection between A and C. And the strength translates as well between binary factors. Yes? So we take that also as a given. So our factor of sustenance really only matters between the emissions and the specific event, and that is the event that attribution science studies. That is the event that compensation claims have in mind. So for this, we call it the 3rd pillar, just to picture it. We use sustenance as an additional logical fundamental to use the findings of attribution science and portray them in our causal analysis, which is, of course, a mental exercise. Yeah? We think about causation. We use 3 logical fundamentals and not just 2. And then we can portray this factor that produces and maintains the effect. When you think about the lake, the greenhouse gas emissions of RWE will have contributed to this increase in risk. They will not completely create it, but they will have contributed, and they maintain it. And as long as you can measure that, you have a contributory cause, and we can picture that in a very coherent way through these additional logical fundamentals. So when we think about this, the Paris Agreement acknowledges some of these causal aspects, and the attribution studies provide these extra scientific evidence that we can use to establish a causal chain between individual emitters or quantity of emissions and specific climate impacts. And I think this new causal matrix allows us to really bring these 2 disciplines together and to utilize the evidence that we have. So we need both. We need litigation. We need these negotiations to produce a really effective outcome that goes hand in hand. And we need the science and we need the law from both perspectives to work together. Thank you.